You are listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to LawWithDenise.net. My name is Denise. In this episode, we're exploring the following. We're asking, what is the Postal Rule? And we're also looking at the case that established this rule, and that case is Adams and Lindsell, 1818. Now let's begin. First of all, I need you to remember and to note that the Postal Rule does not only apply to the post. The Postal Rule applies to non-instantaneous means of communication. And as we saw with Cowan and O'Connor, that the Postal Rule also applied in that case to the telegram. Yeah, so remember that it doesn't only apply to the post, but it generally applies to non-instantaneous modes of communication. And the Postal Rule tells us that acceptance takes place once we put our acceptance letter in the post. So it doesn't take place once the offerer receives it, but rather once we stick it in the post, that's it, acceptance has occurred, and therefore if all the other elements necessary for contract formation are present, we have a contract. And this is contrary to one of the ordinary rules of acceptance, because one of the ordinary rules of acceptance is that acceptance occurs once it is received. And this is why the Postal Rule is a little bit strange, because it is contrary to that ordinary rule, which makes sense, really, that acceptance is made once it is received by the offerer. But perhaps if we look at the facts of Adams and Lindsell, we will be able to understand, get a better understanding of why the courts established this legal principle. So with Adams and Lindsell of 1818, what we had were the defendants who had originally made an offer to the claimants to sell them a quantity of sheep fleeces. Now, they made their offer on the 2nd of September, 1817. And when they made their offer, they said to the claimant that they required acceptance in the post. And this the claimants did do. They sent their acceptance by post. Now, when the offerers made their offer on the 2nd of September, unfortunately, they didn't address the letter correctly. And this delayed its arrival to the claimants and offerees. So that letter, that offer letter, didn't reach the claimants / offerees until the 5th of September. It reached a bit later than would have been anticipated. And when it reached them on the 5th of September, they did put their acceptance in the post immediately. So the evening of the 5th of September. Unfortunately, that acceptance letter did not reach the defendants until the 9th of September. And unfortunately, during that period, the defendants made the decision to sell the sheep fleeces to a third party. And this is where the problem occurred. The claimants claimed that they had made a contract with the defendants, and the defendants had breached that contract when they sold the sheep fleeces to a third party. The question for the court was, had a contract been formed, and when had the contract been formed? The court decided that the contract had been formed on the evening of the 5th of September, when the claimants put their acceptance letter in the post. Remember, there had been a delay with the original offer letter, the offer letter itself that was sent by the defendants, right? There was a delay with that. And because there was a delay with that, things got a little bit messy. Because if that delay had not occurred, the acceptance letter would have arrived would have reached the defendants by the 7th of September. So they had not received their acceptance by the 7th, and they thought that they were therefore entitled to sell their products onto a third party. But the court said, no, you are not entitled to do that, because in fact, the acceptance had taken place on the 5th of September 1817 when the claimants put that letter in the post, and therefore a contract was formed. So they had in fact breached the contract. So there you have it, Adams and Lindsell. Just a quick run through of the main facts of Adams and Lindsell. I hope it helps you to understand things a little bit better. I need you to remember that the postal rule tells us that acceptance is made once the acceptance letter is put in the post, not once it is received by the offerer. And I need you to also remember that the postal rule does not only apply to acceptance by post, but it really applies to acceptance by other means of non-instantaneous communication. So that's it for now. Thank you and bye-bye.
You've been listening to lawwithdenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.